Smith v. Maryland, Supreme Court, 1979. Justice Blackmun delivered the opinion of the court. This case presents the question whether the installation and use of a pen register constitutes a search within the meaning of the Fourth Amendment. Footnote: a pen register is a mechanical device that records the numbers dialed on a telephone by monitoring the electrical impulses caused when the dial on the telephone is released. It does not overhear oral communications and does not indicate whether calls are actually completed. A pen register is usually installed at a central telephone facility and records on a paper tape all numbers dialed from the line to which it is attached. 1. On March 5, 1976, in Baltimore, Maryland, Patricia McDonough was robbed. She gave the police a description of the robber and of a 1975 Monte Carlo automobile she had observed near the scene of the crime. After the robbery, McDonough began receiving threatening and obscene phone calls from a man identifying himself as the robber. On one occasion, the caller asked that she step out on her French porch. She did so and saw the 1975 Monte Carlo she had earlier described to the police moving slowly past her home. On March 16th, police spotted a man who met McDonough's description driving a 1975 Monte Carlo in her neighborhood. By tracing the license plate number, police learned that the car was registered in the name of petitioner Michael Lee Smith. The next day, the telephone company, at police request, installed a pen register at its central offices to record the numbers dialed from the telephone at petitioner's home. The police did not get a warrant or court order before having the pen register installed. The register revealed that on March 17th, a call was placed from petitioner's home to McDonough's phone. On the basis of this and other evidence, the police obtained a warrant to search petitioner's residence. The search revealed that a page in petitioner's phone book was turned down to the name and number of Patricia McDonough. The phone book was seized. Petitioner was arrested and a 6-man lineup was held on March 19th. McDonough identified petitioner as the man who had robbed her. 2. In determining whether a particular form of government-initiated electronic surveillance is a search within the meaning of the Fourth Amendment, our lodestar is Katz v. United States. Consistently with Katz, this court uniformly has held that the application of the Fourth Amendment depends on whether the person invoking its protection can claim a justifiable, a reasonable, or a legitimate expectation of privacy that has been invaded by government action. This inquiry, as Justice Harlan aptly noted in his Katz concurrence, normally embraces 2 discrete questions. The first is whether the individual, by his conduct, has exhibited an actual subjective expectation of privacy, whether, in the words of the Katz majority, the individual has shown that he seeks to preserve something as private. The second question is whether the individual's subjective expectation of privacy is one that society is prepared to recognize as reasonable, whether, in the words of the Katz majority, the individual's expectation, viewed objectively, is justifiable under the circumstances. In applying the Katz analysis to this case, it is important to begin by specifying precisely the nature of the state activity that is challenged. The activity here took the form of installing and using a pen register. Since the pen register was installed on telephone company property at the telephone company's central offices, petitioner obviously cannot claim that his property was invaded or that police intruded into a constitutionally protected area. Petitioner's claim, rather, is that, notwithstanding the absence of a trespass, the state, as did the government in Katz, infringed a legitimate expectation of privacy that petitioner held. Yet a pen register differs significantly from the listening device employed in Katz, for pen registers do not acquire the contents of communications. Given a pen register's limited capabilities, therefore, petitioner's argument that its installation and use constituted a search necessarily rests upon a claim that he had a legitimate expectation of privacy regarding the numbers he dialed on his phone. The claim must be rejected. First, we doubt that people, in general, entertain any expectation of privacy in the numbers they dial. All telephone users realize they must convey phone numbers to the telephone company, since it is through telephone company switching equipment that their calls are completed. All subscribers realize, moreover, that the phone company has facilities for making permanent records of the numbers they dial, for they see a list of their long-distance toll calls on their monthly bills. In fact, pen registers and similar devices are routinely used by telephone companies for the purpose of checking billing operations, detecting fraud, and preventing violations of law. Electronic equipment is used not only to keep billing records of toll calls, but also to keep a record of all calls dialed from a telephone, which is subject to a special rate structure. Pen registers are regularly employed to determine whether a home phone is being used to conduct business, to check for a defective dial, or to check for overbilling. Although most people may be oblivious to a pen register's esoteric functions, they presumably have some awareness of one common use: to aid in the identification of persons making annoying or obscene calls. Telephone users, in sum, typically know that they must convey numerical information to the phone company, that the phone company has facilities for recording this information, and that the phone company does in fact record this information for a variety of legitimate business purposes. Although subjective expectations cannot be scientifically gauged, it is too much to believe that telephone subscribers, under these circumstances, harbor any general expectation that the numbers they dial will remain secret. Petitioner argues, however, that whatever the expectations of the telephone users in general, he demonstrated an expectation of privacy by his own conduct here, since he used the telephone in his house to the exclusion of all others. But the site of the call is immaterial for purposes of analysis in this case. Although petitioner's conduct may have been calculated to keep the contents of his conversation private, his conduct was not and could not have been calculated to preserve the privacy of the number he dialed. Regardless of his location, petitioner had to convey that number to the telephone company in precisely the same way if he wished to complete his call. The fact that he dialed the number on his home phone rather than on some other phone could make no conceivable difference, nor could any subscriber rationally think that it would. Second, even if petitioner did harbor some subjective expectation that the phone numbers he dialed would remain private, this expectation is not one that society is prepared to recognize as reasonable. This court consistently has held that a person has no legitimate expectation of privacy in information he voluntarily turns over to third parties. This analysis dictates that petitioner can claim no legitimate expectation of privacy here. When he used his phone, petitioner voluntarily conveyed numerical information to the telephone company and exposed that information to its equipment in the ordinary course of business. In so doing, petitioner assumed the risk that the company would reveal to police the numbers he dialed. The switching equipment that processes those numbers is merely the modern counterpart of the operator who, in an earlier day, personally completed calls for the subscriber.